All right, let's get started here. Good afternoon and welcome everyone. My name is Andrew Cromer, and on behalf of all of us at AXS Law Group, I'd like to thank you for joining us today. At AXS Law, we've always had a very close connection to the hospitality industry. I myself was an attorney for Shake Shack in New York City for 5 years, and many of my colleagues on this panel have clients that either own restaurants, bars, lounges, hotels, and/or fitness and wellness studios. The hospitality industry arguably may be the most impacted from the crisis, so we wanted to do our part to stay connected to the industry during this difficult time. Our hope is that you'll be able to come away today with some useful tools, tips, and strategies for your business. A little overview of our firm for those not familiar. We are a full-service boutique law firm based in Wynwood, Miami. AXS Law was formed about 4 years ago with the view of disrupting the traditional legal model to better address the needs of modern business law consumers. We pride ourselves in providing practical and comprehensive solutions to complex business matters. Our main practice areas are corporate and transactional law, hospitality, real estate, employment, franchise and distribution, as well as litigation and dispute resolution. Although, based on the last 2 weeks, we might as well add COVID-19, as it unfortunately seems to be an emerging practice area all into itself. All that being said, we do realize that the topics addressed today only represent a fragment of the legal issues facing the hospitality industry. The topics we selected today were based on what we thought might be most relevant to the largest number of you at this juncture of the crisis, based on what we've been seeing over the past 2 weeks. What we will be presenting on today are also admittedly quite broad overviews of these selected topics. Although we will not have enough time to go too deep, we wanted to provide you with a bird's eye view of what we've been seeing. I believe you should be able to see the names and emails of each presenter, so please don't be shy to reach out to any of us should you have any questions. Also, you may see a Q&A tab on your screen, so in real time, feel free to post a question and we will do our best at the end of the presentations to answer as many of them as we can, time permitting. A couple of typical law firm-like disclaimers before we start. This session is being recorded. The information provided today does not and is not intended to constitute legal advice. Instead, all information and content is for general informational purposes only. And with that, allow me to introduce my colleagues, Ben Wolkoff, Jeremy Ben David, Lauren Forenza, and Morgan Ben David. And at this point, I will pass the mic over to Ben, who will be speaking about the CARES Act. Ben, the floor is yours.
Hey, thanks very much, Andrew, and welcome to all of you. I hope this finds you safe and healthy. My name is Ben Wolkoff, as Andrew said. I'm going to be talking today about the Payroll Protection Program, which is a key component of the CARES Act, which was passed last week by Congress and enacted into law to provide federal stimulus for the coronavirus crisis. So what is the Payroll Protection Program? It's a government-funded stimulus program, and it should provide a temporary but really important shot in the arm for small business, including businesses in the hospitality industry. And it'll allow a business to borrow money from a bank or another financial institution with the backing of the federal government to cover more or less 2 months of the business's expenses. And it'll also allow for these borrowed amounts to be forgiven in certain situations, and we'll get into that in a little bit more specificity in a few minutes. So who is eligible? The good news is that it covers any business with up to 500 employees. And a bit of additional good news for those of you restaurateurs who may have more than 500 employees across your system or across the chain of restaurants that are commonly owned. The Act does essentially waive that 500 employee requirement, or cap rather, in certain circumstances. So if you have 6 restaurants, 100 employees at each, the fact that you're at 600 total won't necessarily disqualify you. And that's one aspect of which the law is actually looking at specifically for the hospitality sector. So how do you calculate the total loan amount? Well, what you do is you take the average eligible monthly payroll that you had for the last 12 months, and then you multiply that by 12.5. So I'll just give you a really simple mathematical example. You had $2.4 million in payroll for the last 12 months. That's $200,000 on average a month. So you get to borrow 2.5 times that 200,000. You have a $500,000 loan under the CARES Act. So what does payroll in our example cover? Right? So the 200,000 we came up with wasn't just W-2 compensation. It also included commissions. It includes PTO, medical leave, severance, the value of group health benefits and retirement benefits. It includes amounts paid for state or local taxes and so forth. So what are the limits on what you can borrow? Well, there's really two that we should talk about. One is there's a $10 million maximum, and then there is a $100,000 limitation on calculating the per employee allowance. So if you have employees that are making $200,000, for example, you can only include the first $100,000 and apply the 2.5 multiple on them. So what's the allowable use of the loan proceeds? You can use them on payroll. You can use them on other types of compensation of the type we discussed above for not just employees, but also independent contractors, rent, interest paid on pre-existing debt, and mortgage interest and utilities. Term of the loan. Well, one thing to keep in mind is that this doesn't necessarily even have to convert into a loan, because there's a forgivability feature, of the program that to the extent you use the loan proceeds on eligible expenditures in the first 8 weeks after you receive them, then the proceeds will be forgiven. So for example, in the example I mentioned above, if you have a $500,000 loan, you spend $300,000 on payroll, you spend $50,000 on rent, and you've got no other allowable expenditures, then you will have a $150,000 loan that'll convert into a 10-year loan at 4% interest. The good news is there's no prepayment penalty, there's no personal guarantee required, and there's no collateral that has to be posted. And Andrew will be getting into some of the particulars here relating to hiring and firing and reducing salaries of employees, and how that may potentially impact the forgivability of these loans. So let me talk a little bit about what you can do now armed with this knowledge. Can you apply now? And the short answer is no, but soon you will be able to. The banks right now are scrambling to figure out how they're going to administer these loan programs. We expect over the next few days, perhaps next week, you're going to start to see lenders aggressively marketing these loan programs. But if someone tells you that you can apply now, it's not true, or they're being misled, or it's not true. So what I would do right now is I would contact your relationship lender. Most of them are going to know about this. Most of them are getting ready for this, and gather documentation. Make sure you've got your corporate governance documents, including articles of incorporation, bylaws, operating agreements, get your payroll expense verification forms ready, and finally, stay tuned. We'll keep updating you as things develop. And with that, I'm going to pass it over to Andrew.
Thanks, Ben. Today, I'll be covering various employment and HR considerations in light of COVID-19. This area of the law might be the most impacted by COVID-19, with many of the issues taking shape and form in real time. Since there's so much to cover, I thought I'd touch up on two interrelated concepts. The first, an often asked about concept, furlough, and then the second, HR considerations in light of the CARES Act. So I'm sure many of you heard the word furlough get thrown around recently, so I wanted to dive into what this process really is. In its simplest form, furlough is a mandatory suspension from work without pay. It can be as brief or as long as the employer wants. Typically, an organization will furlough employees as a cost-saving measure when it doesn't want to lay off staff, but lacks the resource to continue paying them. Furloughed employees are absolutely banned from doing any work on behalf of their employer whatsoever. This is a zero-tolerance rule. A furloughed employee can't so much as take a phone call or answer any emails. Even 5 minutes breaks the no-work rule. If a salaried employee does any work while on furlough, the employer must pay them the equivalent of their salary for the entire day. If an hourly employee works on furlough, the employer must pay them for the time worked. As a result, furloughed employees typically have their access to work accounts and devices revoked. This is to prevent well-meaning employees from breaking the law and triggering a payment obligation. Furloughed employees have an expectation that they will return to work. Typically, an employer will give furloughed employees either a specific date or a specific condition for resuming duties. Furloughed employees typically retain their benefits. Most notably, employees usually retain access to any health and life insurance during furlough, but if an employee historically contributed to their health plan, then they are still expected to do so. That's obviously tricky with no income. Furlough is relatively seamless compared to laying off employees, which requires significant work, as does hiring new staff. This can be time-consuming and expensive. An employer typically will use furlough to retain staff that they can't afford but don't want to lay off. Furloughed employees have the right to seek new employment. For an employer, one of the main risks of this process is that the top talent may go elsewhere. Now, how does this work with the newly passed CARES Act? I won't get into all the minutiae of the act, but I do want to highlight a few items, especially the loan forgiveness aspect that encourages businesses to keep their employees employed. As Ben mentioned, through the CARES Act, borrowers can generally borrow up to 2.5 times the borrower's average monthly payroll costs, capped at $10 million. So for example, if your average monthly payroll costs are $10,000, then you can borrow up to $25,000. If your average monthly payroll costs are $100,000, then you can borrow up to $250,000. Companies that employ no more than 500 employees are eligible. Certain companies in the accommodation and food service industry may be eligible if they have no more than 500 employees per location. In most cases, the number of employees is counted together with all affiliates. If the borrower uses the covered funds for covered expenses during an 8-week measurement period that begins when the loan is made, the borrower will be eligible to have the entire principal balance of the loan forgiven by the government. Let's let that sink in for a moment. In essence, that's basically saying the loan could really end up being a grant for your business. That's free money. So how can you make that happen? Well, to be eligible for forgiveness, the borrowed funds must be used for covered expenses such as payroll costs, continuation of group healthcare benefits during periods of paid sick, medical, or family leave, or insurance premiums, salaries or commissions or similar compensation, interest on mortgage obligations, rent, utilities, and interest on other outstanding debt. The amount forgiven will be reduced proportionally in 2 scenarios. The first scenario, if the number of full-time employees is less than the number employed between February 15, 2019 and June 30, 2019, or January 1st, 2020 and February 29, 2020, the choice will be up to the employer on measurement dates. Or the second scenario, if compensation has a significant reduction by more than 25%, with some exceptions. Let's look at 2 examples. Example 1, if you have 20 full-time employees employed during the 8-week period beginning on the date of the origination of the loan, and you had 20 full-time employees employed on average between January 1st, 2020 and ending on February 29, 2020, there would be no reduction in loan forgiveness and you would receive 100% loan forgiveness for the funds borrowed for the above uses. Example 2, if you have 10 full-time employees employed during an 8-week period beginning on the date of the origination of the loan, and you had 20 full-time employees employed on average between January 1st, 2020 and ending on February 29, 2020, there would be a 50% reduction in loan forgiveness and you would receive 50% loan forgiveness for the funds borrowed for the above uses. Now, if an employer has reduced its workforce or reduced wages prior to applying for or receiving the covered loan, there is a provision that allows the employer to rehire employees or increase salary in accordance with the terms of the CARES Act, and the temporary reduction in salary or workforce will not be counted against the employer in calculating the forgiveness amount. Specifically, if the reductions were made between February 15, 2020 and April 26, 2020, those changes are not counted if the business rehires the number of personnel or returns the adjusted salary as applicable by June 30, 2020. I know that's a lot to take. So what's the takeaway here? The takeaway is that you'll want to think long and hard about what makes sense for your business before you make a decision on whether to lay off or furlough your employees now, or perhaps take advantage of the loan forgiveness aspect of the CARES Act. Obviously, if anyone has any questions or needs any assistance with those considerations, please don't hesitate to reach out to any of us. With that, I'd like to pass it over to my colleague, Lauren Forenza, who will be covering force majeure.
Thanks, Andrew. Hi, everybody. I hope you're all doing well, and thank you so much for being with us today. I'm going to be discussing contract enforceability and how to determine whether a party is still obligated to perform or can be excused from performance under a contract due to some of the issues we're seeing from COVID-19. So as mentioned by my prior colleagues, we're already seeing that COVID-19 is having a hugely disruptive effect on contracts, especially in the hospitality industry. And hotels and bars are being forced to shut down across the country. And most restaurants are only being allowed to remain open if they're restricting activity to delivery and pickups. So some of these contracts that are affected may consist of hotel, restaurant, and restaurant purchase and sale agreements, management agreements, construction contracts, supply agreements, and lastly, employment agreements and leases, which some of my other colleagues are touching on here today. Unfortunately, however, not all disruptions being caused by the COVID-19 pandemic in the hospitality industry are going to excuse your performance of obligations under your contract. So how are you going to figure out if either you or a party that you have a contract with is still going to be obligated to perform? Let's take, for instance, an exclusive supply agreement where you have a supplier that's obligated to supply certain goods, say produce or toilet paper in this case, and they've been unable to perform due to COVID-19 issues. The first thing that you're going to want to do is, if you have a written contract, look and see if the contract contains a provision called force majeure. And a force majeure provision explicitly excuses a party's performance of its obligations under contract in the event that certain circumstances happen that are beyond a party's control. For example, a typical provision might say something to the effect of, no party is going to be liable or responsible for the other party or will be deemed to have breached the agreement if any of the following events occur. The provision will then go on to say that to list a number of events that the parties choose to include so that performance would be excused upon their occurrence. And a lot of typical events that you'd probably see listed here are weather conditions, natural disasters, riots, strikes, labor disputes, sometimes pandemics and other illnesses, and then some broad language that I'll get into in a few minutes. So if your contract does contain a force majeure provision, I'd first look to see whether the provision specifically references some form of pandemic. So it likely is, or not likely, it would have been impossible for a party to specifically anticipate and address COVID-19 in the definition of force majeure for prior drafted contracts, just because this was not something that was necessarily foreseeable. Oftentimes, force majeure will contain references to a pandemic, epidemic, serious illness, plague, disease, or outbreak. And this is obviously going to be the most clear scenario where you're likely going to be excused from performance because language specifically addressing a pandemic is included in the contract. So that's going to be your safest bet. If pandemic language is not included, then you can next look to see whether the force majeure definition references any sort of government act, such as a civil or a national emergency. The federal government declared a national emergency, and then as we're seeing, a lot of state and local governments have been having different responses with various degrees of severity. Government orders requiring hotels and restaurants to shut down is going to strengthen force majeure arguments, while less serious action and partial shutdowns, such as allowing restaurants to remain open for pickup and delivery, will get you more into that gray area. And then other force majeure definitions are going to include much broader catch-all provisions, such as referencing an act of God or circumstances that are just simply outside of a party's control. But whether this language is going to be construed broadly or narrowly is going to really depend on what jurisdiction you're in, because every state is going to apply these provisions or apply the law to these provisions differently. So Florida, for instance, is known to more narrowly construe force majeure provisions, and they take the position that parties should not rely on just general vague language in these provisions. And if the event was foreseeable, they really should have just listed it explicitly within the contract. So if possible, you definitely want to see if there's more specific language, either dealing with a pandemic or a government act like discussed. It's worth noting that a lot of times market conditions and financial inability to perform is not going to excuse you from performance under this broad catch-all language. Even if you look back to the 2008 financial crisis, the courts were very consistently concluding that market forces do not count as force majeure. And if they found otherwise, it was because there was an explicit reference to a financial crisis within the actual definition in the written contract. So the takeaway here is you definitely want to rely on more specific language where possible in these types of force majeure provisions. However, just because your contract doesn't include a force majeure provision doesn't mean that you've hit the end of the road. There's a couple other legal doctrines that you may be able to rely on to excuse your performance. And again, the availability of these is really going to depend on the jurisdiction that you're located in. So the first is the doctrine of impossibility of performance, which is relatively straightforward. If performance is objectively impossible, a party is excused from performing. But also relevant here is that this doctrine is also triggered when performance is made illegal. So a lot of these government shutdowns of businesses in the hospitality industry are going to trigger this type of defense, and you'd likely be able to obtain relief under this doctrine. The next doctrine is commercial impracticability, which will relieve a party's obligation to perform when performance is made impracticable by an event not caused by that party, and the non-occurrence of that event was a basic assumption on which the contract was drafted. And this defense is a little more difficult to prove than impossibility because it's not as objective. Lastly is frustration of purpose. So this doctrine is available when the purpose of a contract is frustrated due to unforeseen circumstances or events. And again, courts are typically reluctant to find that a contract has been frustrated. And if you have an express provision contained in your agreement, such as the force majeure provision, then the court is not going to allow you to rely on this doctrine. An example of this would be, say you are a restaurant or a hotel and you were still allowed to be open, but you had a contract for some sort of private event. Maybe it was a private dinner for 20 people. And while you technically could still host the event, you'd probably be able to use this doctrine because you could show that the purpose of the contract was frustrated. Nobody's trying to gather around for a dinner of 20 people right now. So in summary, when you're analyzing whether the contract is enforceable and a party has to perform, I would take the following steps. I would first look within the writing to see if you have one of those force majeure provisions, see if it specifically references pandemic, government act, or some other specific language that you can count on or use against the other party if it's the other party that's not performing. And then if the contract fails to include one of these provisions, you can look to one of those other doctrines that I discussed, which is impossibility, impracticability, or frustration of purpose. And lastly, you should also look to see if there's any sort of mitigation duties in the contract, because a lot of times if you have a force majeure provision in your agreement, it'll say that the party that's not able to perform has some sort of duty to mitigate or avoid the effects of the force majeure event. And then you also just want to make sure that you're looking to the contract for any notice requirements, because sometimes this is a condition precedent to obtaining relief under force majeure provision. So with that, I will pass the mic over to Jeremy, who's going to discuss commercial leases and rents.
Cool. Thanks, Lauren, and hello, everybody. My name is Jeremy Ben David. I am a partner at AXS Law Group. My practice is focused on transactional work, mostly real estate and corporate work. One of the more frequent calls I've received from clients and colleagues are tenants in the commercial rent leasing space, really with the question of whether they need to pay rent due to this pandemic. As everybody who's joined this webinar knows, we're all going through the same thing in some context, and most businesses are struggling right now to make ends meet. Business has either stopped or slowed down materially. So a frequent question by tenants is, do I have to pay rent? And the first place to look is within the lease document itself. As Lauren just touched upon, you got to look at the force majeure clause. In most commercial leases, you may find a force majeure provision. However, it will not excuse the tenant from paying rent due to a force majeure event, no matter how that's defined. So these provisions are typically drafted to be very landlord friendly and not tenant friendly, but it's still worth the look to see if there is a way out from paying rent during this period of time due to a force majeure event. Another place to look within the lease is within the casualty section. Casualty provisions are very often included in leases. However, the way they're drafted is usually related to a physical damage of the premises, for example, a hurricane or an earthquake. And typically if there's physical damage of the premises and a tenant cannot operate and be in the space due to this physical damage, the landlord usually agrees to abate rent, either proportionally or 100%, depending on the while this casualty event is occurring and until the premises can be opened again. However, depending on the language in the lease and how it was drafted, a tenant still may be able to take advantage of this provision. For example, if the language is broadly drafted to say something along the lines of, if the tenant cannot operate in the premises due to any circumstance beyond landlord tenant's control, there could be an opening there for the tenant to make an argument of why they don't need to pay rent under these circumstances. So it is crucial to look at the casualty provision as well in the lease. If there's nothing in the lease itself, in the body of the document, that a tenant can rely on to provide them with a reason to withhold rent during this time, common law doctrines that a tenant can look to, the ones that Lauren just mentioned, impossibility of performance, frustration of purpose, or impracticability are good ones. However, the application of these really depend upon the facts at hand, the circumstances at play here. It's very fact-specific analysis as it relates to a lease. In the context of the COVID-19 outbreak, contract parties will look to invoke these common law principles. However, most courts will view these doctrines of commercial impracticability and frustration of purpose to be applied sparingly, and that for a change in the economic circumstances to justify a non-performance by a party, that party must demonstrate that a change was beyond the normal range of anticipated circumstances. That being said, a drastic change in the revenues as a result of the COVID-19 related shutdowns or government mandated closures may provide some justification under these common law doctrines for a tenant not to pay rent. However, here's a hypothetical to consider and to demonstrate how each case truly depends on the facts at hand and the possible uncertainties of the application of force majeure or any of these legal doctrines. So let's say you have a local baker who tells the landlord that they don't want to pay rent, claiming force majeure. However, it's still doing takeout service. What we're seeing here in Miami-Dade County, lots of restaurants are open for takeout or delivery. So let's say this bakery is still doing takeout service, but they're not open generally. So what's the prevailing wisdom or thought on whether this is allowed, whether the tenant can withhold rent towards the landlord? Well, arguments can go either way, right? And it depends on what the force majeure clause says, as well as what state law provides, including whether you're in a state or a jurisdiction that recognizes common law defenses of impracticability of performance and or frustration of purpose, in addition to impossibility. So in the example that I'm discussing about a bakery, a restaurant tenant would actually be in a better position than a bakery tenant if the government order prohibited dining in and or if the state recognized impracticability or frustration of purpose. That would impact the restaurant a whole lot more than a bakery that would normally have a higher percentage of takeout business regardless of a government shutdown or not. So in this context, a bakery may not have a great argument to make based upon these legal doctrines, while a typical dine-in restaurant may have a stronger standing here. A landlord, conversely, if the force majeure clause did not excuse rent, which is common, or was in a state that only recognized impossibility but not impracticability or frustration of purpose. So, it depends on the type of business, especially in the hospitality context, restaurant, dine-in service only, hotel being forced to shut down. It depends on the nature at hand, the facts of each case, as well as what the underlying documents, as well and the jurisdiction that you're in. So from a practical perspective, each tenant has a lot to consider on deciding whether to withhold rent based upon a common law doctrine or not. Typically, and I do represent a bunch of landlords, landlords won't not necessarily accept a tenant's argument or position that they will of time. So there's some strategy at play here, and a tenant will need to consider the cost involved for legal fees to try to assert any such position pre-litigation, as well as whether, in addition to if it does go to litigation. Even though a lease may have a prevailing party attorney's fees provision, those typically do not cover pre-litigation disputes. So for a tenant to try to take a strong stand to fight back on the landlord, to assert their right here, may be worthwhile to a certain point, because they'll be expending legal dollars to do so. But at what point does the fight outweigh the benefit? If a tenant does decide to withhold rent unilaterally, and a landlord does file for an eviction, here in Florida, in order for a tenant to even put up a defense of an eviction action by a landlord, the tenant would need to place those disputed amounts with the court just to have standing to defend their eviction action. In addition, attorney's fees will have to be paid, even though if you're successful in your action, and I do think there are some strong arguments to be made in possible cases, and you do get your attorney's fees provision enforced, and they'll get to recoup some of that money, there could be an upfront cost that a tenant would have to incur to get those rent payments waived. So some strategies to think about. One, open up a dialogue with your landlord. I think that is, in addition to reading the lease, to have an open discussion with your landlord is vital. Landlords typically do not want to evict folks because it does cost more and it is time consuming to get a new tenant in there, as well as here in Florida, courts are closed to get a tenant to be evicted. It will take a bit of time, and then what? The market for a new tenant to come in and take your place isn't going to be booming once this pandemic is over. So landlords, in my experience lately, have been willing to work with the tenant in some respect. So open up a dialogue with the landlord. And then at that point, take a position about whether, depending on the circumstances, if you want to abate rent, defer rent. One option is to defer the rent that's owed during this pandemic and spread it out over the balance of the lease, amortize it over the remaining months. Another option is just to pay the CAM or the pass-through charges now and defer the base rent over a period of time. Another option would be to the security deposit that the landlord is holding to these months, so the tenant is not further impacted by coming out of pocket and paying rent, with the understanding the tenant will then have to re-up that security deposit as time goes on. Another strategy would be to, if you don't have a percentage rent deal, to possibly modify the lease to portion of the rent of the deferred amounts be satisfied through percentage rent, right? So once the pandemic is over, tenant is still paying their base rent. The amounts during this period are deferred, and that they're satisfied as a percentage of gross sales. That way, it may be a little bit of less of a hit to the tenant, and possibly, depending on the negotiations, maybe the landlord even sees some upside down the line if they're able to achieve even more money on a percentage rent sort of deal. Lastly, look to your business interruption insurance, especially contingent business interruption insurance. There may be some options there for a tenant. And then, of course, getting back to how we started this webinar, as Ben mentioned, apply for these loans that are provided through the CARES Act to obtain some funding. Congress has passed a $350 billion deal for small businesses. So there's some money out there that could help tenants get through this period of time. So in summary, look to your lease. Absent that, there could be some legal doctrines that we can lean on, assert some pressure on the landlords to either have rent abated or deferred. We will have to manage expectations in terms of costs incurred to get to a certain result versus what would actually cost to just pay the rent. So there is some strategy involved, as well as some other options of how we can have a win-win for both landlords and tenants, so everyone can come out of this with business being as close to normal as it was prior to the pandemic. Be happy to speak with anybody after this webinar. Feel free to reach out to me. My email address is right there. And as I said, each case is very unique, fact-specific, and a lot to consider. But we do, both on the landlord and tenant side, we do have some options. And one thing before I forget, if a tenant decides not to pay their rent and unilaterally withhold it without having a dialogue with their landlord, just be aware that the landlord still has rights to charge you late fees, interest, whatever's allowed in the lease. So, it is best to work out some sort of solution with the landlord one way or the other. At this point, I will turn it over to Morgan, who will be speaking about considerations and issues affecting franchise businesses. There are some considerations that are unique to that world. Thanks.
Thank you, Jeremy. Before I continue, I do want to remind everyone who's joining us that there is a Q&A button on the bottom of the screen. So if you do have questions that arise, please type them there and we will do our best to get to the questions and answers at the end. So for those of you who may have joined late, it's at the bottom. We only have about 4 or 5 right now, so don't be shy. So as Jeremy mentioned, I'm going to be talking about issues affecting franchisors and franchisees. For those of you who don't know me or haven't spoken or worked with me before, I do focus my practice on franchise and distribution law. So as you can imagine, especially franchise businesses in the hospitality industry are greatly affected right now. And the common law issues that we've discussed regarding force majeure and the other doctrines that Lauren talked about still come into play in franchising, but where franchises are involved, there's a franchise agreement that governs the relationship between franchisor and franchisee. Like other contracts, franchisors and franchisees did not expect this pandemic. So we're looking at scenarios where franchisors are having to balance the need for strict compliance with franchise agreements and complete uniformity, balancing that with being open to giving franchisees a little bit more flexibility and creativity to deal with the issues as they occur in real time. Because as we've found out, the news changes every day. And unlike a single branded restaurant, in franchising, a decision at one unit can affect the entire system. With that said, the benefit of franchising amidst a crisis is that risk can be shared across all locations, and the franchisor, as the one at the top, should take this opportunity to take a leadership position, because franchisees are going to be looking to the franchisor for direction, information, and how to pivot. So what I will be covering is how we've seen franchise businesses change as a result of COVID-19 and where franchisors can provide a little bit more leeway in terms of business model and operational changes. And then I'm also going to cover considerations in determining whether to keep a unit closed or keep a unit open or to close a unit. And throughout, I'll be mentioning some specific franchise agreement contract provisions that come into play. So I'm just going to mention a couple examples where franchisors can adopt certain changes and where they can waive requirements as stated in the franchise agreement. I'll say that with a caveat, wherever a franchisor and franchisee are coming to an agreement regarding a waiver or allowing something that may not be specifically permitted by the franchise agreement, it's important that the parties document all of the concessions, their agreements, conversations, because my guess is that sooner or later there will be a wave of lawsuits arising from COVID-19, resulting from franchisees' closures and whatnot. So record keeping during this time is critical. So franchisors and franchisees alike should make sure that they're documenting all conversations and keeping the records properly. So with that said, the COVID-19, as I said, has affected local areas differently. Obviously, New York has been affected a lot differently than Iowa. So considerations for franchise units is not a one-size-fits-all approach. The travel restrictions, for example, may prevent franchisors from conducting their regular auditing procedures and their regular inspecting procedures. So in one case, the franchisor may be losing some control, but is what's worse, losing the ability to send a field consultant to make sure the franchisor is using the right table and chairs, or allowing that franchisee to operate. So that's an example where the franchise agreement may say one thing, but reality and the practical considerations will dictate something else. Another example that I've experienced personally is with regard to hours of operations. Usually franchise systems have in their operations manual or daily operations procedures manuals that the unit must be open for certain hours during the day. Curfews have been in place in certain locations. In addition, units may decide that it's just not profitable to stay open during the entire day, and they may stay open during prime delivery hours, given that most restaurants are just resorting to takeout and delivery. As a result, the franchisees should document seeking that latitude around the hours of operation. And during, whether it's the franchisors providing that information to the franchisee or the franchisee making the decision themselves, franchisees should always give a franchisor a heads up so as not to give a reason to create a default maybe later down the line. Another big area that we've seen some flexibility is product specifications. Obviously, the supply chains across systems has been greatly affected. A very simple example is, franchisors will require franchisees to purchase certain supplies, inventory products from certain vendors and certain suppliers. Right now, there's a shortage of cleaning supplies and sanitation supplies. So if the franchisor required the franchisee to buy bulk product of certain cleaning supplies at their affiliate location, but that affiliate location doesn't have any product available to sell to the franchisees, franchisees should be given some leeway to get what they need in order to operate. Ultimately, the decision of how much flexibility and leeway should be given should be considered with the franchisor's role in maintaining brand image over the system. An example that I personally have seen is I was driving by Alton Road recently, and there's the subway there. And if you look on the window, there's a handwritten, huge white poster that says, "We are open." Clearly, if that happened during a regular time, that would be cause for a default notice because that's not an approved signage. But at the end of the day, the franchisors want their franchisees to succeed, because if the franchisees don't succeed and their revenues don't maintain or get back up, the franchisor isn't going to be able to have units in their system or collect royalty fees. Another area where franchisors can provide support and flexibility to franchisees is with regard to rent and lease issues. I'm not going to get into the specifics that were covered with Jeremy, but I did want to note the different nuance that comes into play in the franchising world. The contract is not simply a relationship between a landlord and a tenant, the franchisee or operator, but there's the third party involved, the franchisor. And in most cases, the franchisor will have certain rights, usually in the form of a collateral assignment of lease. And if there is enough negotiation power and the franchisor is a large enough name and has resources, this is an area where the franchisor can maybe provide template letters, template notices to provide to franchisees' landlords, and to clarify that the intent in the franchise system is maybe just to keep units closed temporarily. So it's really, the takeaway of that is that the discussions should involve all three major stakeholders: the franchisee, the franchisor, and the landlord as well. The most common topic and issue that I've been personally dealing with clients is, as a franchisee or as a restaurant or a business that's forced to close down, do I have to pay royalties or do I have to pay advertising fees? My first question is, what does the franchise agreement say? There are some franchise agreements that simply state royalties in the form of a percentage of revenues. There are other franchise agreements that have a minimum royalty that must be paid weekly or monthly. In either case, what's been the most common approach right now is for franchisors to enter into some type of deferral agreement. I'm not seeing straight waivers. So it's really just a wait and see approach. And this consideration depends on, can the franchisor even give that type of leeway? So I do want to just touch up about the issues regarding closure and keeping open. So what if a franchisee wants to stay open despite there being these stay-at-home orders and local laws provisions? It should ultimately come down to, can the franchisee maintain the safety of the customers and its employees? And can the franchisee operate while maintaining brand standards? And this is where the franchisor, if it's dealing with a franchisee that's not cooperating per se, it can turn to the franchise agreement. The franchise agreement will almost always have franchisee must obey all laws provisions, and it will also have a provision regarding defaults regarding health and safety risks. At the end of the day, the decision to close or keep a unit open should be a wide open and transparent communication between franchisor and franchisee, because it's much better to work through the issues together now while everyone's on the same page compared to later when a legal dispute may arise. Lastly, I do want to touch upon, I have new startup franchisors asking me, well, can I still sell franchises? My answer is yes, you still can sell it. I don't know, depending on the industry or restaurant, I don't know anyone who would really be buying a restaurant right now, but this creates a unique opportunity for franchisors who have not yet finalized their documents to go back to their documents and include certain disclaimers in their disclosure documents regarding how long it may take to open. Obviously, right now, it's hard to solidify real estate. It's hard to stick to building schedules and dealing with contractors and whatnot. And given that these issues and consequences as a result of COVID-19 are known, they can now be addressed in the contract. I will summarize with, looking at China and other international economies, the consumer spending has bounced back. So that is the hope. So whether it's a franchisor or franchisee, small system or large, it's important to time when you're going to reopen your business and sync that up with your marketing push so that you can have a much more seamless reopening to the public. Thank you. So that's it for me. I will now turn the mic back to Ben, who will cover insurance-related issues as well.
Great, thanks a lot, Morgan. I'm sure all of you who have been on for about 52 minutes now are excited that you get to hear a few minutes on insurance coverage. But I'll try to keep it really brief. Look, obviously the industry is experiencing rampant losses, and many of you may naturally have gone to your insurance policies to see whether or not you're covered, and you've either found, if you've already made claims, that your insurer has denied them, or they may just be signaling strongly to you that you shouldn't even bother filing a claim. I want to give a little bit more nuance and context on that because, look, a lot of money's at stake, and so it's understandable that the insurance companies are sending out that message. But now you're beginning to see people file claims, especially under their business interruption policies. Thomas Keller, for example, just recently filed a claim, and it'll be interesting to see how those kind of work their way through the courts. So I'm going to give you a really quick fact pattern, and then we're going to quickly run through 4 different types of insurance policies, so you can kind of understand how they work and whether or not you're likely to recover under any of those policies to the extent you actually have those in place. So here's the fact pattern. You make empanadas. You have a contract with Publix to supply them. You have an arrangement with a cheese purveyor. They provide a specific kind of cheese unique to your empanadas, and you need them in order to fulfill your order to Publix. Your cheese purveyor has an outbreak of COVID at the facility. They have to shut the facility, or at least temporarily shut it down. And because of that, you're not meeting your orders to Publix. So are you covered? So let's look at 4 different policies. The first is business interruption insurance. So you're most likely not covered as the empanada maker because you have to show as an essential requirement for a claim under that type of policy that you've suffered damage at your facility. And you can't show that. You can show that the supplier has suffered that, which then means that the cheese supplier in this particular case would probably be able to make a claim, at least on its face, under its own business interruption policy. The second one is contingent business insurance. So this one actually covers you for interruption to your business that results from something that happened to your supplier. So in this particular case, you as the empanada maker would be able to assert a claim under your policy. We'll get into the exclusions in a second, but at least on the face, you could make a claim and you wouldn't automatically be disqualified as a result of the claim. The third one is civil ordinance or civil authority or civil ordinance coverage. There, let's say the county told you as the empanada maker that empanadas are no longer essential. You cannot put them on your trucks and deliver them to Publix. There, you could apply for coverage because a civil authority has told you to stop delivering your product. Finally, environmental insurance. There, it's unlikely that COVID would qualify as a pollutant, so probably difficult to make a claim there. And in any event, the damages that are covered by those types of policies are limited in nature anyway, unlike business interruption insurance policies, which cover lost profits and a whole array of other types of damages. There are a lot of policies that have virus exclusions, so that would seem sort of to be the death knell of any of these types of claims. If you have one of those exclusions, I wouldn't necessarily just sort of throw your policy out on that account. The case law relating to virus exclusions is not very well developed, and we've certainly never seen circumstances such as this. So it is unclear how the courts would apply this. And there may also be political intervention. There are already bills that are being contemplated by various state legislatures that would require insurers to cover certain types of COVID-related losses under existing business interruption insurance policies. So what's the takeaway here? Number one, I've already mentioned, wait to see what happens politically. There may be developments in that regard where you as an insured may get protection where you might not otherwise have it. Of course, there's going to be fierce pushback from the insurance industry. And a related point, do not rely on your insurer to tell you what is covered and what isn't. It's certainly in their best interest to dissuade you from making a claim. Similarly, most brokers don't really have the capacity to read these policies like a lawyer can. Not all of them. Some brokers are very sophisticated and are able to, but this sort of leads us to the biggest takeaway, which is read the policy, right? The policy is just like any other contract. It's a contract between you and the insurer. And just like you would go to your lawyer to review a business contract, you should also have your lawyers look at your insurance policies to see whether or not you have coverage for any given particular claim and whether the exclusions would disqualify you. Finally, gather all of your documents, make sure you don't miss any deadlines. In short, don't buy into the the prevailing ethos, which is that there just isn't coverage out there. It's not necessarily the case. Things may change, and again, there are vested interests that are essentially trying to dissuade you from doing so. So I think that ends the main part of our presentation. I'm going to hand it over now to Morgan, I believe, who will be facilitating some of the Q&A. And thanks for your input on that.
Yes, so right now we'll be going through the questions. We're trying to select questions that could apply more generally. If there are specific questions that we don't get to and you want to speak more about your specific scenario, all of our email addresses are below our name, so feel free and reach out. So the first question is for Ben. The question is, to calculate payroll, does outsourcing staff count? Meaning staff not directly contracted to the hotel, but they're contracted by another company that provides us the service.
Thanks for that. I think that came from David. So the short answer is probably not. There is some ambiguity in the language of the Act, but even though certain payments made to independent contractors would be considered a payroll cost for purposes of applying the 2.5 multiple, it appears that the intent is to cover only expenditures that are in the nature of payroll. So in your particular example, it sounds like what you're talking about is a completely outsourced function, whereas it's a company that provides an outsourced solution. Most likely in that scenario, it would be the management company or the outsourcing solution that would be able to apply for the payroll protection for its own employees. But we could get into the details, obviously, and look at this. But the short answer would be most likely not.
Okay, thank you, Ben. Our next question is for Andrew. The question is, if our company is looking to receive compensation back from the government for paying our employees 80 hours sick leave, do you suggest we furlough our employees after? Would it hurt our position if we furlough them first? Also, how and when should we expect the funds?
So I think each situation is going to be different, and you're going to have to run a calc based on how much you pay your employees, how much loan you're trying to get, if you want it to be forgiven, and when you could possibly hire them based on the timeline suggested by the government. So I think the prudent thing to do is get all the dates in front of you, figure out what your payroll looks like, and try and map out what might make most sense for you. In terms of how and when you should expect to see the funds, all the funds are going to come from banks, right? And the government is going to liaise directly with the banks, and you're going to get the funds from the banks. I think there's been some rumors around that the smaller banks are going to be able to sort of move quicker than some of the bigger institutions. I obviously don't know that as a fact, but just some of the information I've been hearing. And then in terms of when you're going to get the funds, I mean, obviously the goal here is to get the funds dispersed as quickly as possible. I think they're trying to remove as much red tape as possible to make that happen. But of course, it remains to be seen what that process will end up looking like.
Okay, thank you, Andrew. The next question is from Jeff regarding an issue with rent. So the question is directed to Jeremy. Jeff says, we tried to speak to the landlord. He has told us through his property manager that he is not doing anything. He expects his monthly rent. Would we be wise to try and join other tenants to dispute the landlord? By the way, we also asked for a deferment.
So thanks for that question, Jeff. Depending on your business, and I saw you did message me privately about the nature of your business, but generally speaking, for all those on the webinar, there may be grounds that you could assert to withhold rent based upon, again, without looking at the lease itself, but based upon some common law legal doctrines you may be able to rely on, such as frustration of purpose or impracticability. Due to the cost of a long fight, maybe it's wise to team up with other tenants in the building, but every tenant situation may be different. Also, landlords are probably not willing to, or they really can evict you right now, but that's not to say when the court's open that they wouldn't. So if you're not in a position to pay back that rent at that time with late fees, there could be an issue. So, there could be some leverage if you band together with your co-tenants, and if a cohesive message or position could be asserted against the landlord of why rent should be deferred or abated during this time period. Again, depending on the specific facts at hand. But if, for example, there's a government shutdown whereby you cannot open depending on your type of business, that may give you an avenue to put up a stronger fight and increase your position. But again, every situation has to be analyzed on a fact basis, on a case-by-case basis.
Thank you, Jeremy. Next question is for Lauren regarding frustration of purpose. The question from David is, could the figure of frustration of purpose be applied on a ground lease contract? For example, if a hotel cannot operate due to orders of the city, but nothing is said on the ground lease agreement, can the hotel use it to defer the payment of the monthly lease?
So I would definitely just go back and double check the agreement, because even if the agreement doesn't specifically reference a government shutdown, if there is some sort of force majeure provision that has more broad language in it, you could probably categorize this to fall under there, and that would be a little bit stronger of an argument. If the contract doesn't contain anything to that effect, then I think you could definitely argue the frustration of purpose doctrine applies, because obviously the purpose of the contract has been frustrated because you can no longer operate the hotel that's on the land that the lease is for. I would actually also argue for the impracticability defense doctrine as well, because I think that's a little stronger, and you could probably get there as well, just saying that it's impracticable for you to have to continue to pay when you can't keep the hotel open or continue to operate.
All right. Thank you, Lauren. And I think we have time for one more question. This one is directed to Andrew from Ignacio.
Okay.
We have already terminated all of our staff, totaling 40, except those 3 that are allowing us to operate on delivery and pickup. Is this going to hurt us in applying for the payroll protection loan?
So two things to note. One, you'll still be able to get a loan irrespective of what you do, right? It's just whether the loan will be forgiven or not, and where the loan turns into a grant. So I think, let's just say you get the loan and none of it's forgiven because you lay off everybody, but you need to pay off your expenses. I think you're paying 4% on that, right? But because you may have already laid off people and you still want to get that loan forgiveness, there is a part of the act that allows you to rehire within a certain time period and take advantage of employing them back to your team, and then getting that amount of funds from the government turned from a loan into a grant.
All right, thank you. And I did want to mention that we will be sending a round of recorded version of this webinar to our attendees. So if anyone was rushing to take notes, do not worry. And we will be sharing more information as we continue to gather that information and as things continue to develop. So please check your emails from AXS Law Group. We've sent some newsletters as well. And again, our emails are here. Our telephone number, if anyone wants to write it down from our office, is 305-297-1878. And we really appreciate all of you for taking the time to join us today, and we hope that you learned a lot, or at least one thing to take away.
Morgan, can I just jump in?
Sure.
So if you email any of us, it's real simple. Just use our first names, and then it's at axslawgroup.com. That's AXSLAWGROUP.com.
Wonderful.
Take care, everybody.
All right.
Thanks, guys.